I seek or leave to amend the notice of motion dated 5th of October 2018. I'm leading Mr. Sagana. And then I leave to Mr. Sagana and better wrap up. With your leadership permission, they send it in 20. Yeah.
Yes, my lady. All three of us. Yes, all three of us will be talking. Yeah, 20 minutes.
Only two of us.
The leadership, kindly seeking your directions whether the victims will be allowed to say something. Yes, we do. We can take 5 minutes between the two of us. Yes. Most obliged.
I wish to amend the motion dated 5th of October. We read section 123 and 123 in the Criminal Procedure Code. The rest of the articles are correct. Your leadership, the application is bail, upon the next affidavit of Okoth Obado. The grounds on the face of the application. We will adopt the affidavit support in its entirety. By way of submissions, submit that the substantive law in terms of the substantive law that you derive your jurisdiction from Article 165, sub-article 2 of the B of the Constitution, as read together with Article 49(1)H. And in terms of procedural law, you derive your jurisdiction from Section 123 and 123A. Yes. 165 2B and 49(1)H. Procedural law, Section 123 and 123A of the CPC. Under Article 49(1)H of the Constitution, the accused has an automatic right to be released on bail on reasonable grounds, pending a charge or a trial, unless there are compelling reasons not to be released on bail. And bail is a fundamental right. It belongs to each and every individual and is not granted by the state. By virtue of Article 165 2B, the High Court is mandated to enforce the Bill of Rights by dint of Article 20B when applying bail Bill of Rights, the court should adopt interpretation that favors the right of an individual with regard to fundamental freedom. And we urge you to do so. Article 20, Sub-Article 4 of the High Court shall promote the values that underlie an open democratic society based on human dignity. Yes. Yes.
Why don't you adopt those?
I think I'm well guided. I can adopt my previous submissions on bail. And in addition thereto, I urge your Lordship to look at the history of the Constitution of Kenya 2010. The history is very emotive. A lot of Kenyans suffered under the previous regimes, and there was clamor for a new dispensation, which has ushered in a lot of freedoms. Part of the misrule was on account of the judiciary, and it's now time for the judiciary to redeem itself. By giving effect to the provisions of this elaborate constitution. At this stage, the accused person is presumed to be innocent. Your Ladyship, you have now received, like all of us, the committal bundles. And in those committal bundles, there's nowhere where the first accused has been mentioned directly to have links with a crime in issue. The first accused was arrested out of public pressure. At all material times, he has cooperated with the policemen at the investigating stage. And his continued incarceration has led into untold hardship to him and his family. And to the county where is the chief executive. He undertakes not to interfere with witnesses and to comply with all orders of the court. There the offense of murder is serious. Following the Supreme Court decision on Francis Murwatetu against the Republic, it's no longer mandatory to attract death penalty. The accused person would not undermine public order, peace, or security. He's not a flight risk. He's the chief executive of Migori County, and no one can fathom that in that capacity irrespective of fleeing the country simply because he has a case which does not even attract death penalty. The fundamental objective of bail is to secure the accused person's attendance at his trial at all material times. And that is the issue that the court should determine. The amount of bail should not be more than will secure the attendance of the applicant. Neither should it be too large so as to amount to a denial of justice. Each case has to be treated on its own peculiar circumstances. And finally, I would urge your leadership to ignore the press, particularly the print and electronic media, because they have tried the accused person, convicted him before the case has started. With those few remarks, I raise my submission.
On the 27th of September, this court gave a ruling, and in paragraph 64, you held that it was difficult at that stage for this court to determine the bail at that stage before the committal bundles were issued. Paragraph 64. It was difficult for the court to issue before the committal bundles were supplied to the parties. On the same day, the court also gave the first accused liberty to reapply once the committal bundles have been signed. My lady, the committal bundles were served on the 3 accused persons on the 3rd of October. And subsequent to that, we have reapplied for bail. Of importance with the directions of this court, I draw your attention to paragraph 14 of the affidavit of Zachary Okoth Obado, paragraph 9, sorry, my lady. The offense was allegedly committed on the 3rd of September. And the first accused was arrested on the 21st of September. Only I want to point out one, that from the committal bundles there are 24 witness statements. Each and every one of them was recorded before the accused was arrested on the 21st.
Was it on the 3rd? No.
There's no complaint from any single one of those witnesses on any interference or attempt by the first accused.
On that, she gave me.
Secondly, we also note that all the exhibits and documentary evidence in the committal bundles were procured before the 21st. That is the arrest of the first accused. equally with no hitch at all, and more particularly from the first accused persons. There's been a total of 6 persons arrested. Three charged and 3 released. Of 6 persons who were arrested, 3 have been charged and 3 were released. And of those arrested, some were known to the first accused, others were his employees, and they are equally strangers.
They were known or unknown?
Known and unknown. They are both known and unknown persons to the accused, including employees to the county government. Of those 6, he was the last to be arrested. There's no complaint of any difficulty that he posed in the investigation leading to the arrest or release of the other 5. And equally in that period, he recorded 2 statements on the 11th and the 21st. Voluntarily gave samples of his DNA to help in the investigations. And also gave his mobile handset. Well, I would like to emphasize that he did everything asked of him to help in the investigations. That should wrap up the issue of the allegation of interferences of either the investigation or the prosecution in this matter. My lady, I have a bundle of authorities, and I've done a digest, and in the digest I want to refer court to my authorities in that digest number 3, 4, 6, 7, 10 and 12.
3, 4, 6, 7.
10 and 12 of the digest in as far as the allegation of interference in investigations or prosecution. Well, the majority of those decisions are by this court, so I will not belabor on the point, but just to emphasize that the prosecution need to give tangible and concrete evidence of such allegations. What we have before you are mere speculations which cannot take away the rights as enshrined in the Constitution. Well, in paragraph 10 on the issue of presenting oneself for the trial, we've highlighted that he's a resident of Rapogi and Lavington. He has 6 children, 5 of whom are school going. It depends solely on him. is a state official having been elected governor in 2013 and 2017. I'll invite God to read the rest of the paragraph in fullness of time in paragraph 10 on that lane. On the issue of public interest, order and security, lady, I invite God to paragraph 11 and 12 of his affidavit.
You said number?
On the issue of public, paragraph 11 and 12 of his affidavit, on the issue of public interest, order and security. And equally to my authorities, number 12 and 18 in the digest. Other factors, I invite God to paragraph 19 and 20 of his affidavit. The first accused has a severe spinal problem that necessitates him to see a specialist. And we have annexed, as annexed to number 1, a medical report showing his conditions and treatment since 2014.
How much time have they spent? 20 minutes.
Madidi, may I just have 1 more minute to wrap up?
And then your friend will have none.
Just
Because
1 minute.
you have consumed the time.
My lady, we have been served with authorities by the prosecution, and I want to emphasize that this is not an application for review. Of your ruling of 27, but a fresh application, which is guided by the developments of this case, more particularly as directed by this honorable court. And my concluding remark, liberty, my lady, is in the heart of our constitution. And our justice system. And in as far as this case is concerned, it is embodied in the other rights of presumption of innocence and right to bail. We humbly urge that you allow the application. I am most obliged.
Mr. Sasha,
My lady, if you please, I will begin. She will take up from where I stop. Thank you very much. My lady, I wish to begin by saying that I associate, or rather Mr. Oyamo associates himself fully with the remarks of my learned senior, just retired Ombija, as concerns the aspects of law in Articles 165, sub-article 2B, Article 49, 1H, and Article 20. I'll address you with a bit more detail concerning section 123 and 123A of the Criminal Procedure Code.
We can keep it for you.
My lady, safe to add this, that of the rights, the fundamental rights actually, and freedoms that we all enjoy, including Mr. Oyamo, is a right to bail.
Is the right?
To bail and stroke bond. In fact, my lady, my position is this. Once a plea is taken, it is the duty of the court on the date of that plea to tell the accused person, you have a right to bail unless the state presents compelling reasons, and then invite the state to present those compelling reasons. And on this, the court has no discretion. The law speaks for itself, and the court is a custodian of that constitution. It is the custodian of the law, and it has a duty to do so. My lady, in fact, it is the state that ought to have gone first. Then for us to respond to those compelling reasons. If, my lady, you are to require any authority to support those remarks, I would refer you to Article 49, Sub-Article 1H. And in that regard, Mr. Oyamo has filed written submissions so that we can consult the time of court, and I believe they're on record. And we adopt them. My lady, while I'm on that point, I would also like to emphasize that when you're considering this plea, I'm not saying application, my lady, this plea for bail bond, it is important that we take a walk backwards and look at the equivalent provisions in our abrogated constitution. In the abrogated constitution, my lady, bail was at the discretion of the court. In this regard, I do refer you to section 72, subsection 1, which read, my lady, that no person shall be deprived of his personal liberty, save as may be authorized by law. Save as may be authorized by law.
May for clarity, so that we are able to be together, which section 72 is the council is referring to?
He said the old constitution.
Sorry?
The old constitution. So is that not what you are referring?
That's what I'm saying, my lady. Save as may be authorized by law in any of the following cases. And they are enumerated from A to J. And the only time when a person was to be denied bail, as authorized by law, was as per paragraph E, which reads, upon reasonable suspicion of his having committed or being about to commit a criminal offense under the law of Kenya. The law that was contemplated by this section 72 was the Criminal Procedure Code, sections 123 and 124. As when you carefully look at those provisions, my lady, you will see that the provision employs the word may. Since that word may in the Criminal Procedure Code conflicts with our present constitution and therefore gives the court discretion, the court, and I must invite it to so hold, shall need to read that provision excluding that word may. My lady, moving on. Moving on, my lady. My client is presumed innocent, and that needs to be the guiding principle in considering this application. The furnishing of committal bundles to an accused person is a right conferred by law, in fact by the Constitution. But the material in those committal bundles are off the radar of the court when considering an application for bail. I rely on authority that was filed on 11th of October 2018, the case of Kenneth Nyaga Mwige against Austin Kiguta and two others, and the text that is relevant,
You said versus?
Alex Kiguta and two others. And the relevant text, my lady, is paragraph 16 up to paragraph 20 of that judgment of the Court of Appeal, which binds this court. Finally, my lady, I would like to address you on the two affidavits that have been filed by the state and the victim. I will not take too much of your time in adverting to what we have already said in the replying affidavit by Mr. Oyamo. The first one was sworn and filed on 4th of October this year. And you are taking issue with the effort by the state to annex a witness statement and to annex other evidentiary material. And we've requested that the court expunges all those paragraphs which are specifically identified in the first paragraph.
So you said it was annexed in which witness statement?
Witness statement of one witness
And what else?
and evidentiary material, things like post-mortem report, things like occurrence book records, and the like. And that is what the Court of Appeal deprecated very seriously in the decision I have mentioned. As concerns the affidavit of the victim, the entire document has no place in this record of these proceedings. Why do I say so, my lady? I say so because it violates the provisions of Section 9, subsection 2 of the Victim Protection Act, and it also violates Section 12 of the same Act. The only thing that a victim is allowed to do is to file a victim impact statement under Section 12. Not an affidavit. And in this affidavit also, my lady, if you take time to read it, the affidavit of the victim, she's saying she has discussed and she has been told by the investigating officers about this and about that. My lady, with those remarks, I rest my presentation. My live friend, Ms. Katia, will wrap up on the side of the Toyamu's application. Please, sorry.
My lady, I'll use very few minutes to leave some to Mr. Abisai in response. And I'll respond to the issue of the affidavits that have been filed by the prosecution, and more specifically on the annexures of the affidavit sworn by one Clement Mwangi, which my lady gives evidence which is supposed to be produced during trial, as has already been mentioned by Mr. Amulu. My lady, these documents cannot be considered by the court at this stage when making a plea for bail, because they offend the provisions of Article 50K of the Constitution, which gives the accused person the right to adduce and challenge evidence produced by the prosecution. This evidence can only be challenged by the accused person during trial when the documents have been formally produced by the primary witnesses and subjected to cross-examination. Therefore, at this stage, they have no evidentiary value to be considered as compelling reasons to deny the accused person bail, my lady. My lady, the affidavit of Clement Mwangi, if I crystallize it further, the other ground for denial of bail is on the basis of security. And he says that the security of the accused person will be in danger, which is something that has also been alluded to in the affidavit of one Melida. And it is our position that the security of the accused person cannot be a ground to deny the accused person bail. And in this regard, we rely in the authority which we have filed of Cyrus Mwangi, and more particularly from paragraph 5.
Full citation.
Yes, Republic versus Cyrus Mwangi Kimunyu, Republic versus Cyrus Mwangi Kimunyu, 2016, Kenya Law Reports. And more particularly at paragraph 5, that is on page 2 of that authority, paragraph 5, paragraph 6, and paragraph 6. My lady, in that case, Justice Limo has stated that denial of bail on the basis of security of the person would amount to the court endorsing mob justice, and that the court, and it would be a travesty of justice if the court can allow a riotous mob to find an accused person guilty and then lynch him or her. That it is the duty of the state to protect all persons, including an accused person. And in this case, the state has the duty to protect Michael Oyamo and provide him with security under Article 26 and 29 of the Constitution. We therefore urge this court to make a finding that that is not a compelling reason to deny him bail. In his affidavit, the accused person has deponed at paragraph 16 and 17 that he does not intend to visit the home area of the deceased where there could be hostility. No evidence has been produced before this court by the...
You have 2 minutes.
2 minutes. What's the blame on it? Your Honor, the other reason the prosecution have given to deny bail in the affidavit of Clement Mwangi is that the accused will interfere with witnesses. It is our submission that the committal bundle has been given all the evidence the prosecution relies on. There are 24 witnesses have written their witness statements. The accused person has been in custody since 4th of September. By today, that will be about 37 days in custody. He wrote his statement on 9th of September. And during all this time, the investigating officers have not required him to give any further statement.
You said you wrote the statement when?
On 9th of September at Homa Bay. He has not been called upon to write any other statement, and therefore the argument by the investigating officer that the accused should be detained further because the investigation does not complete, we submit cannot lie, since they have not stated in which way the holding of the accused person in custody would assist their investigations, or even provide any evidence how the accused person has impeded any investigations up to now. no evidence, my lady, has been given. As I conclude, my lady, my last point is that the other issue is interference of witnesses. No evidence has been given by the prosecution to make it a compelling ground to demonstrate that the accused person has interfered with any witnesses. In the affidavit of Melida, she has talked of a relative being abducted, which abduction or attempted abduction, she deponds that is the person, the abductors were sent by the accused persons. My lady, the name of the person who was being abducted, the said relative, is not given in the affidavit. The OB extract is not given. We just have an OB number without any particulars. We therefore submit that these are rumors that have not been substantiated and gossip that cannot be used to deny a person his constitutional rights as enshrined in the Constitution. It's our submission that Mr. Oyamo has a right to bail, and it is the duty of the prosecution to give compelling reasons. And based on the affidavits before you, my lady, there are no compelling reasons that would justify denying Mr. Oyamo bail. We therefore pray that Mr. Oyamo is admitted to bail and bond. That is all, my lady.
Good afternoon, my lady. I will begin, and my colleague Mr. Buga will wrap it up. Mr. Oronga will handle the reply. First of all, we would wish to adopt the submissions of learned seniors Mr. Ombija, Mr. Kadana, and Mr. Ombeta as submitted.
Is Mr. Ombeta submitted?
As submitted in both applications,
Okay.
the first and the second. On behalf of the first accused, on the law and principles governing bail, we also adopt the submissions on the law and principles governing bail as submitted by learned seniors Mrs. Ashioya and Mr. Omolo for the second accused. The third accused plea for bail is also predicated on the application dated 27th of September 2018. The affidavit sworn by him on like date.
Affidavit sworn by
Kaspal Ojwang Obiero, the third accused, on 27th of September. As well as his replying affidavit sworn on the 4th of October 2018. Having said that, my lady, and in the interest of time, I would wish to rely particularly on the grounds on the face of the application, the notice of motion, that murder is a bailable offense and the accused person is entitled to be released on bail on bond on reasonable conditions as a constitutional right. This right can only be denied where the prosecution provides compelling grounds or reasons for such denial, and we submit that in this case, none has been provided by the state to warrant the third accused being denied bail. The burden of proof is on the prosecution, and my seniors have submitted in depth on that. We would, however, like to reiterate that nothing in the committal bundles that have been provided by the state, not the witness statements, nor the documentary evidence, draws a nexus between the third accused and the crime of which he is accused before this court. We draw the attention of the court particularly to paragraph 7 of the affidavit, the supporting affidavit of 27th September, in which the accused avers that he willfully obeyed summons and voluntarily presented himself to police on the 18th of September 2018 when he was called upon to do so at the Oyugis police station.
You said it there?
18th of September 2018. Other persons had been arrested in connection with this incident. Most of the witness statements had been recorded by the investigating officers. And the prosecution has shown no evidence that the third accused in any way inhibited their investigations prior to his arrest. No any failure on the third accused's part to cooperate with them even after his arrest. The state is in possession of the third accused's mobile gadgets, as well as other personal effects that were on him at the time of his arrest.
You're saying as well as?
Other personal effects that were on him at the time of his arrest. Including those of his wife, whom the prosecution would like to use as a reason, according to the affidavit of the investigating officer, to keep the third accused in custody. We therefore submit that the third accused does not intend to and shall not interfere with any further investigations, if at all, nor the prosecution of this case. I invite the court to look at paragraphs 3, 4, 5, and 6 of the supporting affidavit by Caspar Lobiero, in which he deposed in summary that
3, 4.
5 and 6, in which he deposed in summary that he is an employee of Migori County. He has a permanent and pensionable job. He's married with children, all of whom are in school. His wife's children and aged parents and in-laws depend on him solely. He has a permanent residence within the country and is therefore not a flight risk. In our plea for bail on his behalf, we wish to reiterate his averment that he shall abide by all terms and conditions set by the court, including attending court at all times, until the conclusion of this matter. He has not received any threats to his person or his family,
And he has not
received any threats to his person or his family, and that can therefore not be a ground for the court to deny him the right to bail pending the determination of this case. It is our most humble plea, therefore, that this court allows the application for bail on terms that are reasonable and give the courts assurance that the third accused shall be present at all times. That is all for me.
Is that possible? You said they shall be present at all times.
When called upon to do so.
How much time is it? Nice. So that you are signing
11 minutes.
Okay, just remind me your name.
Muga.
Sorry?
Muga. M-U-G-A. My lady, I would also wish to associate myself and adopt these submissions from my learned seniors and the submissions from my
learned sister Ms. Angao, and urge my lady to allow the application of the third accused person as prayed. But my lady, allow me to just add a few things. My lady, the prosecution, in an attempt to provide reasons for denial of bail on the third accused person, they have filed an affidavit, or two affidavits, one by the investigation officer, Mr. Clement Mwangi, and there's also the affidavit by the victim. My lady, the two affidavits, in their contents and totality, invite you to, at this particular stage, to look at the evidence in order to exercise your discretion as to whether you will grant or deny bail. My lady, it is our submission that that invitation cannot hold water because the Constitution guarantees that the accused persons are presumed innocent until proven guilty. And at this stage of bail application, evidence or consideration of the contents of witness statements cannot apply. And my lady, we are guided by the decision of your learned brother, Justice Ibrahim, in the case of Republic versus Danson Mguya, which is annexed in our bundle at number 5. My lady, in that decision, the Honorable Judge noted that evidence which supports the charge ought not to apply at this particular stage on the strength of that presumption as expressed in the Constitution at Article 50. For that reason, my lady, we associate ourselves with the submission that the affidavits, the two affidavits, should be disregarded insofar as they purport to introduce evidence before this Honorable Court at this instant. But my lady, if you look at, even if the Honorable Court were to glance at the documents, dispositions that have been produced before this Honorable Court, my lady, you would note that there is no mention of the third accused person. At one point, my lady, you'd note that the prosecution even attempted to introduce the idea of confessions. But my lady, in the committal bundles, there is no confession that has been annexed. There is no witness that has been taken before the Honorable Court to approve their confessions, if at all. So in that, we submit that they should be disregarded. But my lady, the prosecution also, if you look at paragraph 20, 21, and 22, running through 25 of the affidavit of the investigating officer, it attempts to give a reason that the third accused ought to be denied bail for reason that the charge that is facing the accused person is murder. My lady, again, that kind of position is clearly addressed in the Constitution that says that murder is a bailable offense. And the Constitution further buttresses that by expressly stating that every person is to be treated equally before the law. So, my lady, the nature of the charge or the extent of the punishment cannot be a consideration. So we urge you also to ignore those dispositions. My lady, on interference of witnesses or likelihood.
2 minutes.
2 minutes. I'll just wind up. My lady, the prosecution also attempts to say that the accused person, there's likelihood for the accused person to interfere with witnesses. But my lady, there is no evidence that has been brought before you to support that contention. My lady, the affidavits, apart from attaching the evidentiary evidence, the evidentiary documents do not attach anything that shows that the accused person has even attempted to interfere with witnesses. My lady, and that position has also been fully canvassed in the case of Republic versus Amina Yakub at page 8. My lady, they also say that the accused person may abscond trial. My lady, that is just speculation. But more importantly, my lady, the accused person has cooperated well with the prosecution and the police. And my lady, if you look at the committal bundles, the accused person actually was summoned and indeed went to the police. If there was any intention, then he would not have presented himself to the police. And my lady, despite the fact that the accused person has been tried by the public or in the public, my lady, the only solace that the accused person now remains with is the hope that justice will prevail. And that justice is before you, your lady. And the accused person has stated in his replying affidavit that he intends to comply with all the conditions that are set to, all the conditions that will be set as a condition for granting him bail. My lady.
You wind up.
Yes. Lastly, my lady, the prosecution states in the affidavit that the third accused person is an employee of the first accused person. But my lady, what is on record is that the accused person is an employee of the County Public Service Board. And under the County Government Act, it is the County Public Service Board that employs persons in county to serve in county government. So there is no relationship at all between the third accused person, because the first accused person is not the employee. So that nexus that the prosecution attempts to tie the third accused person with the second accused person and the first accused person cannot lie in law. And my lady, we also invite you to ignore the same. So my lady, I am winding up by saying that the affidavits that have been filed by the prosecution do not meet the threshold of any compelling reasons for you to deny the third accused person bail. And for that reason, my lady, I pray that the application be allowed as prayed. Much obliged.
My lady, on behalf of the prosecution, I'm going to address the application by the first accused and the third accused. My colleague, Mr. Muteti, will address the application of the second accused. And I wish to start by adopting our earlier submissions which were followed by the ruling of this court on 27th of last month, and also adopt the authorities submitted and relied upon, which this court has had the opportunity to go through. But for the benefit of the second and third accused, perhaps, my lady, may I point out a few things which seem to escape the second and the third accused counsels. One, we are not saying that bail is not available to the accused person. But what we do say is that bail is not an absolute right. The only rights which have no limitation are the rights under Article 25. And therefore, it is not true to suggest that bail is available as of right, just like rights in terms of Article 25. Several grounds have been posited by several courts in several authorities to warrant denial of bail. And my lady, I'll not go into all of them, but may I mention, one, the seriousness of the offense is a consideration. The likely punishment is a consideration. The possibility of interfering with witnesses is a factor to consider. I'll invite the court to look at the various authorities which we have submitted, and the ruling of this court in the case of Republic versus Frederick Ole Leliman and others, and also the grounds under paragraph 105 of the Criminal Procedure Bench book, that's from page 48 through to page 52.
Which one? There's a
This.
big one, the small one.
Yes, the small one.
48 too?
Page 48 to 52. I realize, my lady, there are several paragraphs which may confuse. That's why I've chosen to refer to page 48 to page 52. Having said that, my lady, I wish to submit that we have opposed this bail, and the prosecution has filed affidavits detailing the grounds for opposition. The defense appears to want to eat their cake and have it. They argue that the prosecution must show that there is compelling reasons to deny accused persons bail. They argue that you need to present evidence before court. Then the prosecution presents some evidence, snippets of evidence. And they beat on about it and they say, you cannot produce evidence.
Yeah. I'm lost. Yeah, so they are arguing that the prosecution must show
Compelling evidence, compelling reasons to deny accused person bond. And they say, to do this, you must place evidence. Then the prosecution does exactly that, presenting snippets of evidence. Then they make an about turn and they say, the prosecution should not have produced this. It's denying the accused person his right to fair trial. But ladies, such arguments cannot and should not be entertained by this court. The prosecution has filed an affidavit, and none of the accused persons through their defense lawyers have even suggested to cross-examine the opponent of the affidavits. All they are asking the court is to dismiss the assertions offhand without any cogent reason. They also argue that the accused has been tried by the public and convicted. I do not take that to be an argument for release of accused person on bail. That is political rather than legal, because if the accused has been convicted by public, why is he here? What are we doing here?
is that a good good question to ask.
That's the question we pose. Even these accused persons have been convicted, we will not be here. So that is an argument which cannot be relied to grant the accused person bail. Then, my lady, the accused persons argue that the accused are married with families. And children. I've never seen anywhere where that is a consideration for grant of bail. And I urge the court to dismiss that argument. Then the accused persons and their defense lawyers argue that the right to bail is a fundamental right, which we appreciate, but we submit, my lady, that there is no right superior to other rights, and the rights of accused persons must be balanced with rights of other persons, other members of public. Then my learned senior, former learned judge, Mr. Umbicha, argues that this court is meant to address the misrules on account of the judicial previous that the misrule we experience today is on account of the judiciary. Under the old constitution. But this is not a political case. This is a murder case. And we submit that the previous misrules, which of course have not been stated before you, have nothing to do with this case. And the factors that the court should consider, which are outlined, my lady, as I've said, in the various authorities, are not cumulative, but alternative. The prosecution need not show that all facts or factors have been established. And the fact that accused persons are not mentioned anywhere in some of the statements so far provided and underline the word here directly, does not remove the fact that a case can be proved with circumstantial evidence. An attempt was also made to show that murder no longer carries death penalty following the decision in the Muruate case. That cannot be far from a lie, because the Constitution does not prohibit death penalty, and the court, in appropriate circumstances, may impose death penalty. And this is a case which we'll be submitting is appropriate for imposition of death penalty if the accused persons are found guilty. And then there was one, I think, misapprehension that the commuter bundles supplied should not sway the court's view. We have not submitted commuter bundles to court, as this is not a trial, and the court will determine this issue of bail not based on the evidence, the totality of the evidence we are going to rely on, but on the cumulative factors we have established through our affidavit. Then Mr. Amolo, my learned colleague, argued that the court is bound to give bail and that it's the state to indicate opposition to bail. We have done this. We did this from the onset, and we have filed our affidavit at the earliest opportune time. And invited the court to apply Section 72 of the old repealed Constitution. The repealed Constitution, my lady, has no force of law anywhere, and it was even his own emphasis that bail may be denied upon reasonable suspicion of one having committed an offense. And we have submit here, we have established here, there is reasonable suspicion that all the accused persons committed the offense with which they are charged. As for accused number 3, argument that he is not an employee of the first accused, I do not know where this comes from, because at paragraph 23 of the affidavit filed by the prosecution, we have clearly stated that the accused is an employee in the county government of Migori. Unless, of course, the argument is the first accused is the county government of Migori. The facts have not changed in respect of the first accused when we were here, other than the fact that, indeed, all the accused persons are now faced with 2 counts of murder. And that is a factor also to consider when determining this application for bail. I'll now invite my colleague to pick up there, and we have arguing with respect to the application by Michael Amo and any other factors.
3 minutes.
3 minutes?
Yes.
I'll try to condense my arguments.
Allow me to begin with the question whether the grant or denial of bail is an issue of discretion by the court. And in my humble submission, Article 49 makes it clear that where compelling reasons do exist, then the court has discretion to consider whether to grant or not to grant bail. That is the position in our country. And my lady, in support of that argument, allow me to cite a decision from the Supreme Court of India. I have shared a copy with my lion friends. The case of Babu Singh, and in that decision, my lady, the court considered, among other things, when a court is to exercise discretion in favor of accused persons for bail and when not to grant bail. In particular, I wish to draw your attention to page 2, the holding as stated at page 2 of that decision. And that covers the renewal of bail applications in stages, such as been done by the first accused. My lady, in exercising discretion, the court is expected not to innovate at pleasure, but to act on well-consecrated principles that courts have laid down on the matter of bail. One of those principles is to be found in the case of Danson Mugunya that my lion friends have relied on. It is in the bundle filed by Michael Oyamo. It's the very last position in that bundle, sorry, second last position. My lady, I will invite you to look at page 369 in black print, 94 at the top. That is unwritten. And the judge, yes, my lady, the judge recognizes that affidavit evidence can be adduced. That is the point we are making. In respect of Michael Oyamo, we have given you evidence. The only point you consider, my lady, then is what is the burden of proof. The memorandum submission, the burden is on a balance of probability. Nothing has been presented to displace the material we have placed before you, and therefore his application for bail must fail. That's all.
My lady, on behalf of the victim, I wish to only submit on 2 points, and Professor Wajakoya will deal with the rest. Your Ladyship, we have perused the replying affidavits that have been filed on behalf of the first and the second accused persons in response to our affidavit filed by the deceased mother, and the submissions of my learned senior colleagues. Your Ladyship, they have submitted that actually our affidavit offends Section 9(2) of the Victim Protection Act. Your Ladyship, it is our humble submission that in fact Section 4(2)(b) of the Victims Protection Act stipulates that at every juncture where a decision is to be rendered by the court, such as the bail application before you, the victim ought to be given an opportunity to be heard or to respond. And therefore, it is our humble submission that filing of an affidavit is the opportunity to respond. Your Ladyship, without belaboring the point, this court has already pronounced itself severally on the issue. And it must be distinguished that the right of the victim to respond or to be heard at the stage of bail application is different from a victim impact statement as contained in Section 2.1 of the Victims Protection Act, as well as Section 12.1 of the Victims Protection Act.
Sorry, I think you lost me a bit there. You said it should be distinguished from?
Yes, that the affidavit we have filed in response to the bail application ought to be distinguished from the victim impact statement as described in Section 2.1 of the Victim Protection Act, as read together with Section 12.1 of the Victims Protection Act, and which restrict the victim impact statement to the sentencing stage. Your Ladyship, it has also been submitted that the matters deponed to in the affidavit by the deceased mother touch on matters to do with the investigation and or conversations between herself and the investigating officers. Your Ladyship, it is our humble submission that the victim has a right to information under Section 19.1 of the Victims Protection Act, as read together with Section 9.1e of the Victims Protection Act, which both empower the victim to be supplied with evidence as well as information by investigating officers in the matter.
My Lordship, I would like to, if you permit me, to say that I'm the last.
I don't know whether I get your name correct. Can you spell it, please?
It's W-A-J-A-C-K-O-Y-A-H.
Yes.
My Lordship, first and foremost, I'm very thankful as I'm the last born today. I think there's nobody else who is going to speak after me other than the other tier that is coming in. We completely adopt what has been said by the state, plus my colleague here, and I will not waste more than 2 minutes, Your Honor, Your Ladyship. That the state has satisfied the tenets of compelling reasons, which I am not in this, at the particular moment, going to adhere to. But the victim's affidavit's reliance on the IO's, investigation officers' point of view is covered in the IO's affidavit. And therefore there is nothing new or anything sinister to be cried upon by my learned counsel on the other side of the aisle. My lady, may I also draw your attention to the maxim of equity. Equity requires clean hands.
all the time. But we have unclean hands here because the prosecution, the defense has come in to denounce their own game plan by saying that the other side of the aisle was relying on evidence. Yet, they have looked into the committee of bundles, which means they have looked into evidence, and they have come out now to say that others should not look into evidence, which means that they're not being sincere with this honorable court, as was previously alluded to by counsel from the state, where they said that we are relying on evidence. Yet they have relied on evidence. How? By reading the bundles. Equity requires clean hands, but they should not come in with dirty hands. I rest my case, Your Honor.
For the first accused, is it? 5 minutes? And try to respond, not to bring argument.
Yes, but I'd also like to indicate that in criminal matters there is nothing like equity.
What is there?
You must prove that beyond reasonable doubt.
5 minutes.
Madadi, let me start by just giving an example that is descriptive. The statute that we are given that shows justice. On one hand, the person dispensing justice has a sword, and on the other hand has a scale, but blindfolded. That was put there not because of just an assumption.
Am I supposed to write that?
Yes, my lady, because if you cannot write it down, at least then listen to what I'll say about it. My lady, there is no chance at that particular moment when you're dispensing justice for you to put that sword down and remove the blindfold, because that means you'll be peeping into evidence. And that's what they're not telling you. That blindfold is there for a reason. So when they tell you look at evidence, then we are at a position that is disadvantaged. And every time they will come to court, they will tell you that they have strong evidence. And that has been what has been put down in many of the authorities. They will tell you that they have strong evidence. How do you have an opportunity to look into that? Because the moment you look into that, again I'll repeat, we are at a disadvantage. My lady, today the prosecution have come up with their response. And I'd like to answer my learned colleagues led by Mr. Ndari on one very simple thing. Interference of witnesses. What have they shown to you today in this court? What have they shown to you? They have shown you nothing. And that is why we said we needed evidence on that, not anything else, that somebody has interfered with a witness, and which witness. For the accused person to abscond, in all those authorities, it has been said evidence must be placed before court. That is the evidence we're talking about. So have they shown you that the accused person, the first accused person, has attempted in any way to abscond or prepare to do so? That is the evidence that we want them to produce to you. And I remember in their first affidavit, they spoke of the influence of the governor. They spoke of the influence of the first accused person in that county. So we left it hanging, hoping that today today, they would show us how that influence is going to affect this case or the witnesses in this case. Till that point today, they have nothing. So then let us ask ourselves, what is compelling reason? Because that is the question they have avoided to tell you today. Those compelling reasons is the material they need to place before court, and they have not done that today. In all the affidavits that they have used to reply, everything there has been on guess form. Let me put it that way. They are guessing. They want you to speculate, to join them and hold hands and speculate with them because they have nothing.
My hands are still
That's why they want to take the sword so that you can. They have nothing, and that is why they want you to join on that aspect. My lady, when an accused person comes before you and tells you he is married and he has got children, what is wrong with that? He has come to show you that he has got ties in this country. He has got reason as to why he cannot abscond. He has got reason as to why he will attend court. And that is where Article 50 of presumption of innocence has to come in, because life must go on. They cannot be in custody because they have children. The presumption makes it possible for them to go on with their life. That is why it is there. It cannot stop. That is why they needed to show you that he has no ties in this country. But they fail to do that. And what do they expect? They are telling you that the accused person, and that is the first affidavit, has harassed witnesses. But the only affidavit that tries to bring up that issue is the article of the victim, paragraph 29 and paragraph 30, which has been... It shows in article 29 that one of the victims was attacked and has reported in a police station. My lady, if you look at that paragraph, clearly shows you the person attacked was attacked somewhere in Nairobi. The affidavit refers, the OB refers to somewhere in Nairobi. Attacked by 5 persons and he was robbed. It's a robbery case, if at all it exists. It has nothing else to do with this case. In that same affidavit, they do not say whether those people mentioned the first accused person. Mr. Obado was there, or that is the one who sent those people. It does not. It does not say where exactly he was attacked. It does not give the person's name, the one who was attacked. So how do they expect you to imagine this situation? So what they needed to do was to bring evidence that the first accused person was actually involved in that attack. In the absence of that, you need to ignore what they are saying. In any case, my lady, no new affidavit has been filed in response to our application. And that can only be one reason. They have no material to respond to that application. They have nothing. Because if they had anything, including the statements that they were harping so much about, today they would have attached them. But in the absence of that, there is nothing. So they cannot come here and stand and start arguing with us and indicate to the court that...
Are you looking at the watch? Huh? It's up.
Huh? My lady, I can't give another 5 minutes.
Because you started by giving us a story.
The story was pretty good, my lady. But my lady, let me just wind up by saying that in the absence of any evidence that they have given you today, in the absence of anything, and they give you an authority, these authorities cannot dislodge the words of the Constitution. whether from India or any other institution. What we are going for is, or by, is the constitution as it is. So let me just give you another example, my lady, and this is the last one. When we come before you, we are lambs. And you are the shepherd. And you have that staff. And that staff is what you use to guard us jealously. And sometimes use that staff to fight even the wolves. And I'm not going to say the wolves are here. My lady, let us not even look at the first accused person with the position that he holds today, because that one they have not responded to. But let us start by saying that this justice that you have to dispense under Article 27, Sub-Article 1, it provides for equal protection and benefit of the law, which is what now they have told you today. They have not said anything about that today. They ignore Article 159. Yes, madam. Article 152, 159, Sub-Article 2. Justice should not look into the status of the person, because if we look at the status of the person today and see because he's a governor or anything else, we will have discriminated against him. We will have discriminated against him. My lady, it is such a struggle with this persecution. Ignore them.
Even though the court is blindfolded, you have to look in everywhere, including yours.
But my lady, look at us.
You're arguing about keeping balances, isn't it?
Yes, my lady. And that's why we would want you to start by...
And that's why the balance has two sides. So if one falls more than the other, that's not fair.
You know what they're doing? They're standing behind you and they want to remove the ribbon. Use that sword for.
I hope you're not making me a shepherd or a butcher. Start with your name.
My name is Abisai.
Abisai.
My lady.
I think I used to know you in the past.
I'm glad that you still remember me. My lady, the prosecution led by my senior Mr. Ndai and Mr. Muteti have not urged any compelling reasons, even as they stood before you. They did not. My lady, all they did was to rely on the affidavit that was filed by their witness. And I want to take you, my lady, to this affidavit of Clement Mwangi. This is an affidavit that is full of falsehoods, some of them very blatant. And I have in mind paragraph number 23. And in this paragraph, they are saying that...
43 or 23?
Number 23, paragraph 23 of this affidavit. They are saying that that Michael Yamo Juma is the governor of Migori County. Yes. They have not even attempted even to correct that. And they want you to believe that indeed this statement of theirs, which is on oath, is what should be relied upon. If they lie on such a material fact, such a basic fact like that one, what else do we know they have lied upon in this affidavit? Much of the material that is presented there is hearsay. All that they have decided to do is to build the prosecution case in this bail application. And your leadership, those are not compelling
And
reasons.
this really responds to this, our submission. They are trying to re-argue the case by buying time through response.
It is on
Let him continue a little bit, then I'll know which
most
way
of
is
that,
going.
your leadership. The compelling reasons, my lady, are different from the evidence that should be presented on trial. They cannot present evidence here and then call this evidence compelling reasons. My lady, Mr. Muteti has quoted the case of Republic versus Mugunya and another, but he has selectively tried to apply the same, and more particularly in on page 370, paragraph E. My lady, that decision is very, very clear, and they would wish that you close your eyes to the same, but this is what it says.
Did you say page 370?
Yes, page 370,
Yes.
paragraph E, where the judge stated that I am of the view that in time, trial courts in Kenya may need to set out basic criteria for our own situation and circumstances. However, I am of the view that most of the criteria set out are reasonable and ought to apply in our cases, with a caveat that the most important critical criteria is whether the accused will turn up on or be available on trial. And more important, it says, I think that the criteria number 2, which is the strength of the evidence which supports the charge, I think the criteria 2 above ought not to apply in Kenya, except where perhaps the application for bail is being made or renewed after the court has placed the accused on his defense. They don't want to tell you that.
Your time is up.
So, my lady, I know in due time you will go and look at this affidavit very critically. And we pray that in absence of any compelling reason, they have not presented any, kindly grant accused number 2 bail. That is our prayer.
Please, for the card, please.
My lady, I am present. My lady, I will be very good. My lady, in response, first we reiterate the submissions earlier made on behalf of the third accused person. My lady, we join hands with the prosecution in appreciating that bail is right. That is the rule. The second limb of that particular article brings an exception, which is the provision of compelling reasons. And humbly, Your Ladyship, we submit the prosecution has failed. At your own time, Your Ladyship, we urge you to look at the affidavit on which the prosecution is laying its claim. That is the affidavit by the IO. Very cleverly, they have merely rehashed the ground set in the bail and bond policy guidelines and section 123 of the CPC. Almost word for word. But where is the disjoint, Your Ladyship? They have merely thrown the allegations based on that section to the face of the court. My lady, not a single attempt to prove any of those grounds. Zero. In fact, Your Ladyship, in the attempt, they clandestinely.
No, but my lady, I don't think.
My lady, he does not know what I want to say.
Whatever you are going to follow, what is going to follow?
I will rephrase, Your
Clandestine
Ladyship.
is you know the.
I will rephrase, Your Ladyship. They cleverly.
In fact, everybody should quote the bail and bond.
Yes.
It's a good thing.
They cleverly, Your Ladyship. He is even losing me, what I was saying. But I'm saying, Your Ladyship.
You are using the word clandestine, which of
Yes,
course it
they
doesn't.
cleverly bring out evidence meant in proof of the charge, not of compelling reasons. So preliminarily, Your Ladyship, they are trying to get to the back of the head of the court what evidence they have in support of the charge. What my senior Mr. Ombet is saying, removing the ribbon. Your Ladyship, you've been referred to authorities by the prosecution, specifically the authority of Olele Liman, Republic versus Olele Liman. In response, I will be brief, Your Ladyship. One, each case should be decided on its own facts. And two, and most importantly, Your Ladyship, we urge you to look at our bundle of authorities, specifically authority number 3, number 5, number 10, and number 12. Your Ladyship, they give you an answer.
Authority number?
3, 5, 10, and 12. They give you a response to every issue raised by the prosecution. Melody, you have, they have pointed to proportionality of rights under the Constitution.
You wind up.
I am winding up. The proportionality of rights, my lady, I'll refer you to Article 24(1)(d). My lady, if you read that together with Article 24(2)(c), the answer is there. In that they should not use that proportionality to derogate even the rights accorded to the accused person by the Constitution. Look at the paragraph 23 of the affidavit, my lady, you will find very interesting facts. They call my client PA to the governor, working at the behest of the governor, which is a misleading fact. Finally, in winding up, my lady, they have correctly put out that the third accused has not been mentioned anywhere, but saying that circumstantially somewhere along, he may be tired. I will leave that to the court. And humbly, Your Ladyship, we will beseech this honorable court to be pleased to consider the third accused person's application. Find that there are zero compelling reasons provided by the prosecution, and humbly admit the third accused person. That's it.
I want to give you a ruling on the 24th at 9 o'clock, 24th of this month. Anybody with a problem with that date?
Yes.
24th of October?
Yes, my lady. We would urge the court on behalf of the second accused, if it is possible to get the ruling earlier, considering that the accused has been in custody from 4th of September.
If 24th is not good, I push forward.
We are praying to come earlier, my lady.
No. In fact, this is too early. I should push it a little. So 24th, 9 o'clock.
Lady, that is the earliest.
Yeah, it is the earliest.
We shall excuse me.
There will be a ruling on the 24th of October at 9 o'clock.
Yeah, obliged. This is yours. This is yours.
What is the judge?
All bets on sports. One is fair. Huge winnings. One is fair. High odds. One is fair. Pharmaceutical Company.
Oh, my husband. Oh, my husband.
Cholera is very, very close.
You need to be very careful about the food you eat. It has to be covered and it has to be steaming hot from neat places. Cooperate with the environmental health workers at the hospitals, and when they come to disinfect your homes, listen to them. Keep your food covered and store your water safely. When you are given drugs, take them till they are finished. Always remember, wash your hands with soap under running water.
Arabia Lefay Road was a no-go zone for the past